A seminar on the executive, democracy and the judiciary took place in Colombo, and it was attended by the former chairpersons of the Bar Association of Sri Lanka, university teachers, civil activists and others. President's Counsel Dr. Jayampati Wickramaratne expressed these views.
අධිකරණයේ ක්‍රියා කරන්නේ රාජ්‍ය නාමයෙන් වුවත් එය නීතිය සම්පාදනය කරන ව්‍යවස්ථාදායකයන් මෙන්ම නීතිය ක්‍රියාත්මක කරන විධායකයන්ද වෙන්ව.
Though the judiciary functions in the name of the state, it must be separate from the legislature and the executive. When it comes to domestic debt optimization, the President said that the government will not heed orders or advice from any other party except Parliament. The Speaker of Parliament also noted that any proposal passed in Parliament cannot be challenged in court. Clearly, this is wrong. Any proposal or regulation in Parliament can be reviewed in court, and it was further stressed by Justice Veeramantri in the case of K. Rambanda versus the River Valleys Development Board in 1968. We as the Lawyers Collective emphasize that there can be no direct or indirect influence on the judiciary when reviewing government operations as per the Constitution and as per the law. We will unite for democracy, rule of law and the independence of the judiciary. It is our responsibility to speak up for the judges who have not been able to speak when judicial independence is threatened.
ගංගා නියමන සෞමාර්ධන මණ්ඩලය නඩුවේ. ව්‍යවස්ථාවට හා නීතියට අනුව රජයේ ක්‍රියාමාර්ග සමාලෝචනය කිරීමේදී ඍජුව හෝ වක්‍රව අධිකරණයට කිසිදු ආකාරයෙන් බාධා නොකළ යුතු බව නීතිඥ සාමූහිකය අපි අවධාරණය කර සිටිනවා. ප්‍රජාතන්ත්‍රවාදය, නීතියේ ආධිපත්‍ය සහ අධිකරණයේ ස්වාධීනත්වය කෙරෙහි අපගේ දැඩි කැපවීමෙන් අපි එක්සත් වෙනවා. තම ස්වාධීනත්වයේ තර්ජනයක් වූ විට තමන්ට කතා නොකළ හැකි විනිශ්චයකාරවරියන් වෙනුවෙන් කතා කිරීම නීතිඥ වෘත්තියේ අපගේ වගකීමක්. එය තමයි අප මේ ඉෂ්ට කරන්නේ.
Professor Vasantha Senaviratne from the University of Colombo pointed out that executive, legislature and the judiciary should function with balance.
අපේ ආණ්ඩුක්‍රම ව්‍යවස්ථාව පැහැදිලිව කියලා තියෙනවා මේ පරමාධිපත්‍ය බලය තුල ක්‍රියාත්මක වන්නේ.
The Constitution makes it clear that the mandate is the people's executive power and the people's judicial power. It is a fundamental right. Therefore, all the institutions must function and exercise their powers as per the concept of the fundamental constitution. If government institutions function in a manner that undermines the aspirations of the people, the value of the mandate is also undermined. The devolution of power cannot be executed in a verbatim manner. There need to be some checks and balances. It is not wise to award excessive powers to an institution, and doing so would erode the mandate of the people and the fundamentals of democracy. Therefore, the judiciary needs to remain independent.
එබඳු රාජ්‍යක ජනතාවගේ තමා සතු ඒ ඊටාම වැදගත් අයිතිවාසිකම් යටපත් වෙනවා කියන එක. ඉතින් අන්න ඒ කාරණේ නිසා තමයි අපි දකින්නේ අධිකරණය ඊටාමත්ම ස්වාධීන විය යුතුයි.
Former President of the Bar Association of Sri Lanka, President's Counsel Salia Peris, also attended the forum.
අපි නීතිඥ සාමූහිකය හැටියට බලාපොරොත්තු වෙන්නේ නීතිඥ ප්‍රජාව ඉදිරියටත් මේ රටේ මිනිස්සුන්ගේ අයිතිවාසිකම් වෙනුවෙන් කටයුතු කරයි කියලා. මේ රටේ අධිකරණයේ ස්වාධීනත්වය ආරක්ෂා.
As the Lawyers Collective, our aspiration is that the legal community will continue to represent the rights of the people of this country. We hope the country's legal community will have the strength to protect the independence of the judiciary. The Hindu newspaper in India refers to the legal community as the voice of reason. We understand the importance of an independent judiciary. Former SSP Shania Besekara understands the importance of a strong judiciary. We do not have the ability to appoint committees and take months to review issues and then wait for the reports of the committee. We also have no use of those who do not fulfill their duties. The legal community has a responsibility and they must fulfill it. That is how the legal community functioned in 2013 during the impeachment of the Madam Chief Justice. We hope to strengthen the legal community through this movement. The issues in the country are worsening. There is an issue with democracy. There is a crisis in governance. Institutions need to be strong, and the foremost institution that needs to be strengthened is the court.
This is of governance. පාලනය පිළිබඳ ප්‍රශ්නයක්. ඒ තුල ආයතන ශක්තිමත් වෙන්න ඕනේ. ඒ ආයත ශක්තිමත් විය යුතු ආයතන අතර ප්‍රමුඛ ආයතනයක් තමයි අධිකරණය.
Parliamentarian M.S. Sumandiran also spoke at the event.
Judiciary has a separate, a distinct and an important independent function in the structure of democracy, and that must be preserved whatever happens. That space for the judiciary must not be transgressed into by the other organs or anyone else. We do criticize judgments. Learned professor is here, academically, even otherwise, wrong judgments are openly criticized, and that's good. That is good for the judiciary, that's good for democracy, that's good for freedom of speech. But we will not allow the judiciary to be attacked, the judiciary to be subjugated and made to follow the dictates of others. Independence of the judiciary is fundamental to any democratic system. Time and again, this happens, that the rulers who constitute the executive and are part of the legislature think that they must have their own way, that there must not be any interference into what they think is their preserve. But that is where an independent judiciary comes in, to protect the rights of the citizen, to protect the rights of the people, and in that functioning, the judiciary has a singular and a very specific, important role to play. Not just between citizen and citizen, but nowadays more and more between the state and the citizen. To uphold the social contract that we have in the form of our constitution, give it efficacy, give it effect, so that it's not dead letter,